Call the list.
Daily list, bail hearing, item number 1.
You have the CD.
Lordship, records, search seated case, Lordship. Record, the CD part is not there, Lordship, in the record.
Answer. Have you seen it?
Yes, Lordship. Only the report was there, several times attempted, Lordship. Yes, but several times attempt there, Lordship. He was
7 times?
several times, attempt was made by several times.
Several times.
He was absconded, Lordship, and the search sheet. During investigation time, he was not cooperating, and the search sheet he has shown absconded, Lordship.
My submission is that Lordship charge sheet already been laid, Lordship. And so let him to appear before the trial court, Lordship, and any condition, Lordship, who will be appear and face the trial, entire trial proceeding without.
No, I can dispose it off for you to appear before the trial court.
And
Trial
trial court
court
will
should
decide on merit.
consider in accordance with law, but I am not giving you any relief here.
Lordship.
Only Lordship 10 days maybe, Lordship, and the section is there, Lordship, the trial court having no jurisdiction to grant bail, Lordship.
Till he approached the trial court, he may not be arrested.
Lordship only.
But only thing is that the Lordship, he approached the trial court will decide on consider on.
All right, I'll.
Lordship.
You are Mr. F. Hawk.
Lordship.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr.
DP Goswami.
D.P. Goswami, learned APP for the state respondent.
Lordship.
For the state respondent. Earlier, similar FIR this court has dealt.
Lordship.
This is an application under section 482 of BNSS 2023 seeking pre-arrest bail to the petitioner I. Motibu Rahman, who is apprehending arrest in connection with PR case number 1254
Lordship.
of 2022, registered under section 143, 323, 352, 302 of IPC, arising out of Dhing PS case number 52/2020, pending in the court of the Subdivisional Judicial Magistrate, Nagaon.
Lordship.
This is the same. Earlier, there was this Motibur Rahman.
Lordship.
This is arising out of the same FIR.
Lordship.
The case of the prosecution is that since 2 years,
Lordship.
the accused person were using the informant's motor pump and have refused to pay the hiring charges. Accordingly, on 9/2/2020, when the accused persons had come to the pediphiles, the informant refrained them from using the said motor pump. However, later on, around 9 p.m., when the informant was returning home after closing his shop, the accused, the petitioner, along with the co-accused, stopped him and threatened him. And next day at around 9:30 p.m., who is accused number 11? That's not the petitioner, right?
Not
No.
The accused number, the co-accused number 11 interrupted him and got him down from his motorcycle. And after the informant left, the said accused number 11, along with the co-accused, including the petitioner, came with dao, lathi, etc. And by seeing the father of the informant standing in front of the house, they assaulted him.
As per the
Stop.
contents,
That is the allegation.
Lordship.
The younger brother of the informant was also alleged to have been assaulted. The informant's father, who was assaulted grievously in the forehead, ultimately succumbed to the injury and died. Accordingly, a case was registered, and after completion of investigation, charge sheet was submitted on 30/11/2020. Stop. Mr. So-and-so Hawk, learned counsel for the petitioner, submits that the petitioners are willing to surrender our petitioner is willing to surrender himself and appear before the trial. Mr. So-and-so Goswami, learned EPP, strongly opposes the prayer for bail and submits that the accused petitioner have been absconding since the date of occurrence, and the materials collected implicates the accused for the offense alleged. Stop. I have considered the submissions made at the bar and have perused the materials available on record. The allegations are of grave and serious nature, considering the fact that the accused persons have been absconding since the date of occurrence, I 9/2/2020. This court is not inclined to grant anticipatory bail to the petitioner. Stop. However, as per the endorsement made by the learned counsel for the petitioner, Mr. F. Hawk, this court is inclined to dispose of the anticipatory bail application by directing the petitioner to appear before the jurisdictional trial court, and when the petitioner appears before the jurisdictional trial court, the learned trial judge shall consider the prayer for bail in accordance with law.
Lordship, I'm sorry, Lordship, one submission, Lordship. Obliged. Obliged.
Mr. Gogoi.
Met with your lordships.
Yes.
Yesterday, lordships have directed to clarify in respect of Annexure 9 and Annexure 10. Annexure 9 is page 44.
Yes.
First of all, my lord, may kindly mark it. Cabinet memorandum circulated under Rule 17 of Assam Rules of Executive Business 1968. My lord, may kindly mark it. Now, lordship says to peruse what is the Rule 17. Internal page 4 also.
Yes.
When it, lordship, I can read it.
4, but which clause?
17 lordship.
17.
17. It
Yes.
was under Rule 17 of the Assam Rules of Executive Business 1968. Rule 17 lordship.
Yes, I have it.
When it has been decided to bring a case before the cabinet, the department to which the case belongs shall, unless the chief minister otherwise directs, prepare a memorandum indicating with the sufficient precision and on the salient facts of the case and the points for decision. Such memorandum and such other papers as are necessary to enable the case to dispose of shall be circulated to the ministers. Copies of the memorandum and other papers shall same time sent to the governor, lordship. So, lordship, this is a document prepared by the lordship department to place it before the cabinet, lordship. It is never attained finality, lordship. That particular document was not approved by the cabinet. It's only a lordship, 17 rule circulated under rule 17
You mean
lordship,
to say it's a proposal.
proposal lordship. Proposal which to be placed before the cabinet lordship. And page 46 also, lordship, last two lines,
Where have you said that in your affidavit?
lordship.
Have you said all this in your affidavit?
We have not stated, but otherwise this document itself says that, lordship. This document, they
No,
cannot,
but the case of the petitioner is on the basis of these two
this
documents.
document, lordship, no right is
You
equated.
have filed your reply.
We have filed, lordship.
Okay.
This document, no right is equated by the petitioner. We have the specific point in the affidavit we dealt with, whether they are entitled for the UGC scale of pay from the date of acquiring PhD or from the date of appointment. We have replied that part.
No, but this document is enclosed as an annexure to the writ petition,
Lordship,
correct?
lordship,
And there must be a supporting paragraph.
lordship.
In against that paragraph, what was your
Lordship,
response?
the document itself says that, lordship.
Document is another thing,
Lordship.
but you see, you.
If lordship permit, I can, by way of additional affidavit, I can
No,
bring
no,
it that.
we are now at the hearing stage.
We have not
Before, but-
stated, we have not stated, lordship.
So simply say that you have not stated. that.
We have not,
Because
it is a lordship, it is not a paragraph wise reply, lordship, probably. It is
You have
not a
not
paragraph,
filed a paragraph.
No,
reply.
lordship.
Why?
it is not a paragraph reply, only we have filed the affidavit, whether he is entitled or not.
Then you are risking yourself, you know.
Lordship.
I don't
That
think
part I
need
will
to-
satisfy,
I
that
don't
part I will,
think, Mr. Gokul, I need to tell you about
Lordship.
how a denial has to be made,
lordship.
correct?
I will satisfy whether he is entitled or not, lordship
All
has to
right,
decide.
you are making a point,
This
I've
is the,
understood.
on the basis of that
All right.
particular document, no right was
All right.
equated to the
I've
petitioner,
noted.
and this document was
According
never,
to me, this is a proposal
This
which
is a
has not
proposal,
been
it is-
accepted.
not been accepted, even cabinet also cannot be accepted, lordship. If for a timing, lordship, they assume that that proposal was accepted by the cabinet, that there is existence of the document, then also no right is equated to the petitioner. We cannot override the statutory prescription prescribed by the statute, lordship. We have no power, lordship. Even that particular document was not, lordship, executed, not attained finality, lordship. Recent 2024 judgment of the Honorable Apex Court in the Manipur High Court cases, where the full bench, full court of the Manipur High Court taken a decision relaxing certain conditions of the district judge's appointment. Then also Honorable Supreme Court says that even full court has taken decision, it cannot be treated. It cannot override the statutory prescription.
What was the statutory prescription here?
I will place it one by one. I will just, lordship says yesterday pointed out two queries. Now I have to clarify that. First thing, that is the annexure 9, lordship.
Hmm.
It is never attained finality, lordship.
All right.
And regarding second part, lordship, annexure 10,
Hmm.
my lord may kindly mark it. The minutes of the meeting of the pension board held on 4/5/2005 in the office chamber of the Honorable Minister of Education, Janta Hobang, lordship. It's a minutes of the meeting, lordship.
Hmm.
It's a minutes of the meeting between the education minister and officials of the higher education department and other, lordship, officials of the college teachers associations, lordship. It is not a decision of the government, lordship. It is a minutes of the particular meeting, lordship. That minutes cannot override the statutory prescription, lordship.
Because that minutes, read the second paragraph,
Lordship, lordship,
read the third paragraph.
lordship, lordship. After three-way discussion, it was agreed unanimously to implement the pension scheme as per the formula worked out by the department. How can one committee can formulate the scheme, lordship?
The family, I don't know about
Lordship.
that, but this is your, these are not minister or officers of another state.
Lordship,
They're officers of your state.
lordship, this
You
is
are
a,
representing.
this
the
is
state.
a minutes of the meeting of a committee, lordship. That committee
They are
cannot,
your people,
Lordship.
headed by the Honorable Minister Higher Education.
lordship, lordship, I am not denying, but he cannot change the statutory prescription prescribed by the statute, lordship. By way of a meeting, lordship.
Read below.
I have read it, lordship. The meeting further agreed upon to withdraw of the condition net slate for the college teachers appointed up to 12/1/2000 and to allow to enjoy all benefits vis-a-vis career advancement, etc. to the teachers appointed from 13/1/2000 to 22/2003 are exempted from net slate up to the extent of giving great scale of pay. They cannot, lordship. They cannot. By a minutes of the meeting, we cannot change the, lordship, the statutory prescription prescribed by the statute, lordship.
Okay. Now what is the statutory
Lordship,
prescription?
lordship. So for that, purpose, my lord may kindly come to page 25. What is the advertisement?
Yes.
Applications are invited from the candidates for the post as follows. Post of lecturers candidates should bear the UGC norms, lordship. This was the advertisement issued 1999, lordship. At relevant point of time, what is the UGC norms, lordship?
UGC norms are under 309.
Lordship. Lecturer, lordship, 4.0 lecturer.
Yes. Besides fulfilling the above qualification, candidate should have cleared the eligibility test.
Net and slate, lordship. This is the UGC's required qualification prescribed by the statute, lordship.
When you say net and then you say slet, I don't understand. What does slet mean?
Slate means state eligibility test.
But where is
Net
that
means
mentioned?
national eligibility test. lordship.
Here they are only mentioning net, right?
Net, lordship, at that relevant point of time, state was
And
not,
because of that, even yesterday I was,
lordship.
it was coming in my mind, I forgot to pose that question. That with net, it is always said sled, but when
Lost.
I read, I don't find.
Lordship, net. At
Slate.
that relevant point of time, when it was lordship implemented by the UGC, lordship.
So yeah, as per 4.41, at that relevant point, one of the condition which was required to be followed is in order to be qualified is net.
Net, lordship.
Now this is framed under
Under lordship, section 26 of the UGC Act, lordship.
where do you get that? Yes, where do you get that?
Lordship. In exercise of power, section 26.
Next, let's go to your affidavit. Where are all this?
Lordship.
This is the UGC
Lordship, lordship,
Act.
lordship, lordship.
So these regulations are framed under 26.
Section 26, section 26. lordship. So, lordship, as because at the relevant point of time, lordship, he has not the required UGC's qualification, lordship, UGC's norm. So, lordship, the appointment arise in page 28. It's a conditional appointment. Page 28, lordship.
20.
28, 2A.
That I remember. It says till somewhere it is mentioned, right?
Page 28, lordship.
Probation.
Probation. It's a conditional appointment. The petitioner has accepted that particular conditions.
To be discharged as she. Somewhere it was mentioned.
Page 28, my lord may kindly peruse,
No,
lordship.
no, your, I think 26. Subject to the conditions as stated in the said letter. Okay, then comes joining.
Yes.
Then comes 16.8. Would be subjected, sorry,
Lordship,
it
lordship.
is here only.
Lordship,
Would be subjected to clearing of net.
lordship, lordship,
Right.
lordship.
There are cases that this has been subsequently by a cabinet decision has been relaxed.
No,
This is-
lordship.
that is their case.
At
That is their case.
lordship, at
But
no,
according to you, that cabinet that the cabinet
that proposal.
meeting which has been relied,
No,
which is Annexure 9, is only a proposal which never was accepted.
never was accepted. At no point of time it was accepted. Even lordship 2012 lordship, government has issued one OM lordship. By relaxing the persons who have obtained MPhil degree prior to 2009, they are exempting from the qualified condition of net and slate. Then also our Honorable High Court has lordship interfered with. You cannot override the principles prescription prescribed by the lordship, that particular statute you cannot override. And that was also lost in 2014. I'll place it, Lordship. 2015, our High Court, my Lord Justice Ujjwal has passed their judgment that again the same line, Honorable Supreme Court in 2015. One case came from UP, Lordship, P. Susila's case also, Lordship, affirmed that you cannot change it, Lordship.
You cannot change,
You can.
relax.
We cannot relax it, Lordship. Even in that particular case, Lordship, the persons who have acquired PhD also not considered by the Honorable Apex Court.
In other
But-
words, the ratio probably is that if a statute requires a particular
That Nazir Ahmed.
condition, that cannot be relaxed
Yeah.
by way of an executive instructions or
Lordship, Lordship,
unless and until
Lordship.
it is done by the rule makers.
Lordship.
Correct. Probably it is in
That
that.
is the principles, 2000 PV Council's 1939 principle that was reiterated again and again.
So that principle will apply if we hold this UGC norm to be statutory.
Lordship,
First, there has to be that finding
Lordship,
that these UGC norms are statutory.
Lordship,
If they are statutory,
Lordship,
whether they can be relaxed by,
Lordship.
which of course, according to you, first of all, there is no relaxation.
No relaxation.
Because that proposal was never accepted.
Even Lordship, the regulating authority UGC in 2010 Lordship, in 431 general meeting and 432 general meeting, adopted a resolution, Lordship, whereby they have relaxed the persons who have obtained the MPhil degree from acquiring net and slate. In 2010 Lordship, the regulating body has taken the decision. But that particular decision was negated by the central government. and-
Despite the regulating body having.
But yes, Lord, despite the regulating body decision, that was negated by the central government under section power conferred under section 20 of the UGC Act. That central government says that the standard of higher education, you cannot dilute it, Lordship. You cannot compromise the required minimum qualification. That was put to silence before the Honorable Allahabad High Court. Allahabad High Court was rejected. Then Lordship again it has come to the Supreme Court. Supreme Court says that the direction given by the central government is binding between the regulating authority, Lordship. Then Lordship, this is the criteria. Our main intention is that Lordship, the petitioner will get the UGC's required scale of pay from the date of obtaining the PhD degree, Lordship. From the date of obtaining the PhD degree, Lordship. There is no dispute.
So there is no dispute.
No, then they claiming that from the date of appointment, they are entitled for UGC scale of pay.
So
Or-
you are not disputing to the fact that they will get the higher scale from the date they have.
Yes, Lordship, there is no
they have
dispute.
got the PhD.
We cannot, Lordship. We cannot. He is entitled from the date of PhD. He is entitled, Lordship. But he is seeking the UGC's scale of pay, whereas he has not the required qualification of UGC. If a person has not or have not the required qualification, how he can, Lordship, seek that particular benefit, Lordship? There
But
is
yeah,
no dispute.
But the order says the appointment is, he is appointed with the condition, with the subject that is, that he shall clear net slate.
Lordship, let's say. Till then, he should be treated as a probationer. So, Lordship, the fixed pay is there, skill pay is there, Lordship.
So that is what you are trying to say.
Lordship, Lordship.
Okay.
And regarding Lordship, whether at that relevant point of time, when advertisement was issued, what is the UGC's required qualification? That was only settled by our High Court. In several judgments, I will place one by one, Lordship. It says that in 1998, Lordship, it is the net slate and net and slate, Lordship. 55% of marks and net and slate, Lordship. I will submit that. Now, Lordship has to decide one more question here, Lordship. Whether petitioner is entitled the UGC's required scale of pay or get pay from the date of acquiring PhD or from the date of appointment, Lordship. That questions Lordship have to decide, Lordship. Only that particular limited question, Lordship. Nothing more, nothing less, Lordship.
Is entitled to
UGC's required
Grant.
scale of pay,
grant of UGC
scale of pay or promotion, scale of pay less promotions from the date of acquiring PhD degree or from the date of appointment, Lordship. And in that particular point, my one-line submission is that, Lordship, he is entitled for the UGC's scale of pay and promotions from the date of lordship,
Yes.
acquiring the
Yes.
UGC's required norms lordship. And it is a conditional appointment lordship. He was accepted the conditions. He has joined the post lordship. At no point of time up to 2015, he never challenged that post. It is lordship covered by the Honorable Supreme Court judgment. In Palanaswamy's case, it was decided even after 6 years also they have opposed, challenged the conditions. The Honorable Supreme Court says that you cannot. And it was reiterated in Surendra Singh case in 2015. I will place one by one judgment lordship. Now, lordship, for particular moot question, I will place two judgment of our High Court lordship, where it says that at the relevant point of time, what is the UGC's required qualification. Good lordship. Moot question, sir, please. 2017 Zero Supreme GIU 668.
Zero Supreme,
Hi, sir.
page,
Page 668.
the Guwahati bill নাথাকে নাকি?
Guwahati GIU থাকে, sir.
G-
GAU.
oh,
GAU. Here is a case lordship
Yes.
where the particular person was appointed lordship in the year 2000 lordship in 18/9/2000 lordship.
Hmm?
18/09/2000 lordship.
18?
18/09 to it is paragraph 4 lordship.
Yes, I got it.
Paragraph 4 lordship. 18/09/2000. There is a condition was stipulated lordship that he or she should acquire net and slate lordship. And after obtaining MPhil degree,
This is a single judge's order.
it is a single judge's order.
কি নাম petitioner?
It is Deepshikha Das.
Yes, offer was accepted.
Lordship, lordship,
And
lordship,
she joined
lordship,
after 10 years.
lordship, lordship. After 10 years, she has challenged lordship. And after obtaining the MPhil degree, she came before this honorable court that I have obtained the MPhil degree. From that day onwards, I have to given the lordship that particular UGC scale of pay. Then lordship may kindly come to paragraph 7 lordship. Paragraph 5.2 also lordship. Paragraph 7 my lord may kindly come. This is a affidavit filed by the University's Grants Commission's lordship. The University Grants Commissions is represented by Learned Counsel so it refers that the UGC's notification and revision of pay scale of minimum qualification for appointment of teachers in universities and colleges and other measures for maintenance of standards 1998 that regulation lordship. This is already placed before your lordship. To contend that when selection was made and the petitioner was appointed, the UGC's norms applicable for appointment of lecturers is a good academic records 55% of marks, master's level, and also qualifying the national eligibility test or an accredited test. Such stipulation is mandatory and accordingly the council argues that so and so lordship.
Yes.
And after that lordship, the department lawyer's submission is here lordship, exactly the same footing. The lordship permit, I can read the paragraphs.
That's all right.
Lordship.
Para 10 you may read.
Para 10 and 11 lordship.
Yes, read.
Para 10. The inability of the petitioner to secure the net and slate qualification is attributed by her Learned Counsel to denial to study leave of the college authorities for what the petitioner had to secure MPhil degree in the distance mode from a Singhani University so and so. It is submitted if study leave can be availed by the petitioner, she can make an earnest attempt to the equate to the net slate and PhD class. This court is mindful of the fact that petitioner on account of the stipulation in her appointment order is doing lesser salary than her colleague in the college, but at the same time the petitioner is not at par with the regular faculty members doing full salary as they satisfy the UGC norms to allow dwell of the equal pay lordship. Basically, UGC's norms is lordship at the relevant point of time, net slate or lordship the qualification that part lordship. Other point is lordship in respect of
Yes.
acquiring the PhD and others. Yeah.
Yes.
Yes. Then Lordship. Dada, objection? It's a single judge's judgment, Lordship.
Yes.
5779/2016, Lordship.
Para.
I'm starting from paragraph
Give the
14.
reference, Mr. Chaudhary.
Lordship.
Give the reference to Mr. Chaudhary.
That's my, Matlab, against this writ appeal is pending.
Okay.
But this order was never stayed, Lordship. It is Lordship still holding in the field, Lordship.
No stay.
No
but
stay.
there the context was different. There what happened, my lord? Advertisement is of 98. And my lord, the recommendation of the selection board was contrary to the, sorry, while governing body, while forwarding the case for seeking approval, my lord, the second nominee's name was sent. I was the first nominee, Jyotirupa Sharma. Then what happened, my lord? This honorable court eventually interfered. So it was in that context. It is not like here. The facts is different.
Okay. But to what point do you want to
I-
press
I-
this case?
I refer this case on that only particular moot question. What is the required qualification at the relevant point of time? Nothing else, Lordship. So, Lordship, paragraph 14, Lordship.
Paragraph 14.
Paragraph 14.
In that case, this question never cropped up. In that case, the
Right,
question
let
was in the meantime, my
Mr.
lord.
Chaudhary, let him finish his
In
submission.
that case, this is one of the moot
Alright,
question which was
alright.
framed by the Honorable Court, Lordship.
All right, Mr. Gogoi.
I am on the basis of the
Make
record.
your submission.
Lordship.
I'm taking note. Yes.
Lordship, I am obliged, Lordship. From the submission made on behalf of the petitioner and the Higher Education Department, it appears that the following points arises for decision in this case, Lordship. My lord, I kindly mark it. Whether the condition of net slate or PhD was prevailing before the advertisement dated 6/6/1998 was issued, Lordship. Then whether the petitioner would be entitled to UGC's scale of pay on or from the date when she had cleared net slate and earned her PhD degree, Lordship. Then, Lordship, whether based on the fact that some others who were appointed under same advertisement were given UGC scale of pay without having cleared net slate and PhD, the petitioner would be liable for the same benefit by applying the rule of parity, Lordship. Whether
But
by
here the question was whether
One
whether a
and-
petitioner would be entitled to UGC pay scale on and from,
Lordship,
not before.
Lordship,
It is on and from.
on and
And
from,
you have already said that you have no problem
Lordship.
for
From
grant-
this day.
from this
That's
date.
Lordship, that is the two questions, two
No,
basic questions,
here the pre-question is not, it doesn't appear in para 14
Lordship.
that that the issue whether one is also entitled from the date of appointment.
Lordship, this is the one of the reason is that, Lordship, she is claiming the UGC scale of pay, Lordship.
No, Mr. Gogoi, I'm just trying to point out from
Lordship,
paragraph 14
Lordship,
that Roman 2, it in the factum of whether pre is not in the mind of the court while framing this issue number 2, because here it appears they have only specifically taken whether one is entitled on and from.
Lordship,
Clear.
he is claiming,
Hmm.
that particular petitioner is claiming from the date of, Lordship, other persons who have given before the acquiring of the net slate and
Where
PhD.
here,
Here,
in
Lordship,
this case.
in this case, Lordship.
Okay.
It is reflected from the third point, Lordship.
Okay.
Whether based on the fact that some others who were appointed under the same advertisement were given UGC scale of pay
All right. this-
without having clear, Lordship.
Oh.
That is the moot question framed by the Honorable Court, Lordship.
All right.
So, Lordship, first point which was decided by the Honorable Court is point number 1, issue number 1 and 2. They have, Honorable Court has decided, Lordship. So, Lordship, make paragraph 15, Lordship. Issue number 1 and 2 reflects, Lordship, what is the required qualification at the relevant point of time, Lordship. The point number 1 and 2 are taken up together. The Learned Standing Council of so and so has produced a copy of the IGC notification dated so and so 1991. I will place the notification also, Lordship. That notification. So if Lordship wants, then I can place.
That's all right.
No.
Hmm.
It's 1991.
Which notification? 1991.
1991.
All right, you give it. Why don't you put all this by way of a compilation after
Well,
you
let's
finish
see.
the?
I'll play.
I think because you see, these
I-
acts that you have given me, Mr. Gogoi,
I'll provide.
all this would be also required. You make a compilation.
I'll
of all
provide.
this.
Everything I will provide. Everything I will provide. Just I am indicate Lordship. What is the qualification at the relevant point of time also, 1991 also. This one is 7 also, no? Then 1991 onwards Lordship. Before that also 1987 Lordship. The minimum qualification prescribed by the UGC you cannot dilute Lordship. 3 point Lordship, lecturers Lordship.
Should have cleared the
TL also.
eligibility.
TL
Should have
also.
cleared the eligibility test for lectures.
Sure,
Kannada by
yeah.
English. All right.
The said notification has been issued in exercise of power conferred by clause E of the subsection 1 of section 26, read with section 14 of the Universities Grants Commission Act 1956. The said notification has superseded previous notification dated 83, 85, and 85 Lordship. In Schedule 1, thereto the following qualification is prescribed in respect of the post of lecturers Lordship. Already Lordship has perused it. I am not reiterated Lordship. Then paragraph 16 Lordship. In the notification dated 1991, clause 2 contains a non-obstance provisions to the effect that no person shall be appointed to a teaching post in university or any other institution, including constituent or affiliated colleges recognized under clause F of section 2 of the UGC Act 1956. Moreover, under clause 11 of the notification dated so and so 1987 Lordship. This is the 1987 notification Lordship. I'll place the notification also
This
Lordship.
earlier one was 98,
Lordship.
the one which you had given 4.0.
Lordship.
That is a
24/12/98.
98.
And Lordship, this was 1991 Lordship. 1991. 98 also here discussed. I will place it Lordship. The notification dated 1991 clause 2 contains a non-ostensive clause provisions that to effect that no person shall be appointed to a teaching post in university or any institution, including constituent or affiliated colleges, recognized under clause F of section 2 of the UGC Act 1956. Moreover, under clause 11 of the notification dated so and so issued by the Government of India, Ministry of Human Resource Development Department of Education also prescribed to the effect that only those candidates who, besides fulfilling the minimum academic qualification prescribed for the post of lecturers, have qualified in a comprehensive test to be specially conducted for the purpose will be eligible for appointment of lecturers Lordship. Therefore, in the light of the contents of the said to notification, the court is
Are
unable
you
to.
carrying us that Sushila's?
I have Lordship. Everything I will place Lordship. Therefore, in the light of the contents of the said to notification, the court is unable to accept that the petitioner would be entitled to wish away the qualification requiring clearing the eligibility test for lecturers. There is no dispute that net and slate is a such eligibility test prescribed to be cleared for appointment to the post of lecturers. Similar condition requiring net and slate is reiterated amongst others in the subsequent UGC's regulations on revisions of pay scales, minimum qualification for appointment of teachers in universities, colleges, and other measures for maintenance of standards 1998. That regulation Lordship. 17 Lordship. From the contents of the OM dated 13/1/2000, it appears that the Government of Assam Higher Education Department adopted the so-and-so regulation and conjoint reading of the 1E of the OM dated 2000 and the 4.4.1 of UGC regulation 1998. It appears that the Government of Assam has prescribed the following qualification for lecturers: good academic records with at least 55% of marks on an equivalent grade to the master's degree level or any equivalent degree from the foreign university, besides clearing the national eligibility test. The provisions requiring that to be appointed to the post of lecturers, a candidate must have cleared the net is found to be pre-existing prior to the date when the petitioner was appointed as a lecturer. Here also Lordship similar. The learned standing council so and so submitted that the as per so and so that is later, this is not required. Otherwise, Lordship. Next paragraph 20 Lordship. Here, paragraph 19 also, my lord may kindly peruse. The learned counsel for the petitioner had submitted that the petitioner had cleared UGC net held on 2013 and the date of qualifying net is 21/10/2013. It was also submitted that the petitioner has also qualified the award of PhD Guwahati University on 1/4/2016. That is in that particular case, you see. 20. UGC's regulation 1998 requiring minimum qualification is in the greater interest of the students for which the said regulation must be allowed to prevail over the desire of the petitioner to claim pay increment and or higher pay scale while she lack of requisite qualification, lordship. Here also same thing. He is claiming, lordship, the UGC's higher scale of pay, lordship, without having the UGC's required qualification, lordship. 21.
And he has accepted that of
Lordship, offer of
terms.
appointment, lordship. In this regard, we find support from the decision of the Honorable Supreme Court in the cases of P. Susila so-and-so, where the UGC had granted
I've
exemption.
read all this, but for your benefit, you want to complete, you complete.
Lordship, yes, because then.
Otherwise, I've read. You can complete for your benefit, but I'm indicating.
Lordship, then lordship, then not required. Then lordship, the point number 3, lordship, is it issue number 3?
I saw.
Issue number 3, lordship.
Paragraph 24.
Issue number 3, paragraph 24 onwards, lordship. He also accepted the conditions, lordship. And regarding issue number 4 also, lordship.
Issue number 4, paragraph.
Issue number 4 is, lordship, paragraph 30 onwards, lordship.
This issue 3 from 24 to 29, right?
29.
At the end, it says, therefore, the point of determination of 3 is answered in the negative by holding that even if some others were appointed under the same advertisement
Lordship.
and were given UGC's pay scale without having cleared net, the petitioner would still not be liable for the same benefit by applying rule of parity.
Yes. And it was reiterated, lordship, even lordship, recently on enable.
This one, this is of 12/5/23. Okay, this appeal is still pending.
Even lordship, Honorable Supreme Court on lordship. On November 13, 2024, reiterated that negative principle 3 judges based judgment. I will place that
Which
also.
one?
In November 13, this month, lordship, Honorable Supreme Court also decided that part. What was indicated by my lord in this judgment, lordship, that was also that principles was again reiterated in November 13, 2024 by the Honorable Appeals Court in a 3 judges bench judgment. I will place it also, lordship.
And also that's Sushila.
P. Susila, lordship. P. Susila. P. Susila, position. Okay. Yes. P. Susila.
It's all right, you can give it together.
P. Susila, lordship.
Negative equality. 96 of my assay.
P. Susila, lordship. কথা বললো? দুটা কপি দিলাম।
Paragraph.
Lordship, Mylon में para 8 onward, 8 the facts is there, lordship. Why these cases before the honorable court? Internal page, lordship, 140, lordship. Paragraph 8, lordship.
So this is that MPhil case.
Lordship, even PhD also not considered in this case. Paragraph 8, lordship. By to resolution dated 12/8/2010 and 27/9/2010, UGC opined that since the regulations are prospective in nature, all candidates having MPhil degree on or before 10/7/2009 and all persons who obtained PhD degree on or before 31/12/2009 and had registered themselves for the PhD before this date, but are awarded such degrees subsequently shall remain exempted from the requirement of NET for the purpose of employment lecturers and assistant professors, lordship. Then, lordship, paragraph 9, lordship. The central government, however, by letter dated 3/11/2010 informed
So
UGC
this
that,
PhD was recognized from 2010 onward.
lordship, after that,
From,
no,
from
originally 2010 was there. Even lordship, other, before that also PhD was there, but
Was
they have
there.
to fulfill NET is there, lordship. Otherwise, there's subsequently one judgment of the Honorable
But
Apex Court
from 2010, it is PhD is
in lieu of net
sufficient.
slate, even
PhD
Lordship,
sufficient.
PhD was earlier also considered. That particular Pisusila judgment was Lordship again Lordship considered by another three judges bench of the Honorable Supreme Court that says that the PhD persons also
But here that is not the issue because it is you have agreed that from the date
no
The
issue, Lordship,
petitioner has
no issue,
PhD.
no issue. He is
now
entitled
the only issue is whether from the date
prior
of
to obtaining the
that
UGC.
clause 3
Lordship,
the issue number 3
Lordship, it was answered, Lordship,
that perhaps
answered, Lordship,
answers
answered that part. It is answered, Lordship. It is answered. So P. Susila's case is this, Lordship. And regarding that similar line, Lordship, another judgment also there, Lordship. June, yes. Lordship. Sir, it is Junudi. Junudi. 480216. And Junudibi case also lodged that appointment letter and joining that table, my lord may kindly peruse internal page 6 lodged.
page
Internal page 6, paragraph 3 lodged.
yes
This is the table lordship when they have got appointment letter and when they have joined lordship. It was prior to 2003 lordship. All are. One is 2000, one is 2001, other all are 2001
Yes.
lordship. There. Here also they are claiming lordship the same benefit without acquiring net slate and PhD. Then the answer is negated by the honorable court. I am not troubling lordship. This is the
para
all the paras lordship. Some everything is discussed lordship. Everything is discussed lordship.
anything
Lordship.
your affidavit
Lordship. And other 2-3 cases also there lordship. If lordship permit, I can just hand over it lordship. Computer case lordship. Right, it is. In this case also lordship, particular person was appointed by the college in 1997 lordship. But it was by OM dated they were lordship regularized with a conditions that with a conditions that lordship lordship they have to acquire net slate or PhD lordship the stipulated period of time 2 years. And she came before this honorable court. Honorable court negated her claim lordship. With paragraph 3, 5, 6, 9, 10, and 11, I am relying. Lordship, kindly mark it and I will.
paragraph
Paragraph 3, 5, 6, 9, 10, and 11, Lordship.
but these are all coordinate bench
Coordinate bench, coordinate bench.
this issue has not been decided by the division
Division bench, otherwise it is a well settled principle of the honorable apex court. It is already, it was decided, Lordship. In the P. Susila's case, it was decided, Lordship. Even the regulating authority has no power to, Lordship, exempt that particular condition. This is the principles laid down by the Honorable Supreme Court in the P.
in
Susila's
that
case,
case of course that was the issue
Lordship.
but this in these cases of our high court
Lordship.
that you are pressing
Lordship.
there this very issue itself is
Itself, single bench already decided it is holding in the field. There is no stay and not a single case, Lordship. Even Lordship, another cases, Honorable Court, other case also there, Lordship.
if it is the same point then it is all right there is no point of
Same point,
multiplying.
other case also, Lordship, even Lordship, we have wrongly given the UGC scale of pay, Lordship, 1 person. We have wrongly given, order was issued, Lordship, wrongly given UGC scale of pay without having the UGC norms. After that, when we have realized, Lordship, after contempt was also before this honorable court, contempt was closed, Lordship, on the basis of the order issued by us, wrongly order issued by us, where we have given the benefit of the UGC scale of pay. After that, we have realized that he is not getting, and we have not given him the UGC scale of pay. So she has approached this honorable court. That findings of the honorable court is that rightly, wrongly, that order was given by the authority, as because we have not obtained the UGC required scale of pay, UGC norms,
In
so you
other
are not
words,
entitled.
the norms are important
Norms are important. This is the judgment, Lordship.
Mr.
I'm not troubling, just
Gogoi,
I'm-
you do one thing because otherwise.
I will make a compilation
make
and
a compilation.
compilation and,
index.
and provide Lordship.
Yes.
And Lordship, regarding our affidavit, Lordship,
I've read it.
Lordship, this is my humble submission, Lordship.
Yes. Wait, please, your lordship. My lord, in our writ petition, we have clearly averred that this was the cabinet memorandum. My lord, normally what happens, whenever a cabinet memorandum is approved, all that happens is, my lord, will be placed before the cabinet and there will be a small word written approved, nothing. Now, my lord, whether it is approved or not, we do not know. We have made categorical averments in para 6 of the writ petition. There is no denial. So my learned friend will have to perhaps file an affidavit regarding the status of that. Because he's saying will not do. It is his, well, end of the day, there is an affidavit saying that this is the cabinet memorandum.
Why don't
Yes,
you clarify
under
that
rules.
stand, Mr. Gogoi?
That he will do, Miller.
What I can do, otherwise,
No, because Mr. Chaudhary,
No, no.
if that,
my lord.
if that has to be
Yes,
done.
otherwise lordship
then-
cannot decide on facts which is
No,
not clear.
Absolutely right.
Yes.
Now, if that has to be done,
Yes.
then I don't think
Now,
any
assuming, my
purpose would
lord,
be
assuming for the
served
sake,
carrying forward with the hearing.
yes, no, my lord, assuming for the sake of argument that this cabinet memorandum was not approved, even then lordship will kindly appreciate my argument.
But one thing, Mr. Chaudhary.
Yes.
This cabinet, suppose assuming the cabinet has given approval,
Yes.
can they relax the statutory?
My lord, whose case is it? Whose case is it that there is a requirement of exemption? That's my learned friend's perception. I'm coming to that. My lord, who is seeking exemption? Now, my lord, kindly see. Let us be very clear about few dates. What is the date of, lordship will kindly take note. 9/10/99 is the date of advertisement.
9/10?
9/10/99.
Yes.
Now, my lord, UGC regulation is dated 24/12/98.
Yes.
And state government adopted the UGC regulation of 98, sorry, 24/8/98, my lord.
24/8.
8, not 12.
Hmm.
And UGC regulation of 24/8/98 was adopted by the government of Assam on 13/1/2000.
13/1.
2000.
Yes.
Now, on the date of my lord advertisement, net slate was not a requirement. Even though 24/8/98 do prescribe.
Adoption doesn't.
No, adoption took place post the advertisement.
All right, all right, all right, all right.
Am I clear, Miller?
All right, all right.
Now,
Yes,
for
it's
a
cleared.
moment, lordship will kindly come to
But
that.
in that situation,
Yeah.
there must have been some other UGC regulation.
No,
putting
my
the-
lord.
No.
No. Now, my
So
lord,
according to you, on the date of advertisement, there was no UGC norm.
therefore,
existing.
Manjusri and all this case will come into play. Now, my lord, please come to page 44 of the writ petition for a moment. Now, this is a cabinet memorandum where education department has laid the facts for the purpose of facts, not for the purpose of the decision. Kindly see, my lord. All appointments made in the post of lecturer of deficit grants in colleges before 13/1/2000 were approved without imposing any condition for clearing net slate. So there is no dispute. Before 13/1/2000, all appointments were cleared without insisting on clearing net or slate. Then my lord will kindly come to paragraph 2. Government of Assam Education Department accepted the revised UGC norms and guidelines wide OM dated 13/1/2000. So, my lord, only for the purpose of these two facts, I have read it again. So, my lord, two facts which clearly, two undisputed facts are before 13/1/2000, whenever appointments were made, net slate were not insisted upon. Now, our advertisement is of October 99, where, my lord, there was no question of advertisement prescribing net slate. Am I clear, my lord?
Yes, but
Yes.
it does say UGC.
Now, I'll
norm
come,
or
my lord.
Something, right?
Now, I'll come to that Sarma's case, that my case, I remember the facts, my lord. Now,
No,
my lord will
in
kindly
that,
come to this judgment. Yes, Kalyani Motivanan. My lord will kindly have this judgment. My lord, this is Kalyani Motivanan, and this has been the stand of the state government before this honorable court in several cases, that UGC norms should be applicable only when it is adopted by the state. Now, please come to my lord, paragraph 62 at page 396.
only the relevant paragraphs have.
Yes, my lord, 62.23.
Yes.
Kindly see, my lord, in view of the above discussion as made above, we hold, please come to 62.3.
Yes.
UGC regulation 2010 are mandatory to teachers and other academic staff in all central university and colleges thereunder, and institutions deemed to be universities whose maintenance expenditure is made by UGC. In other words, UGC regulations are mandatory qua central universities. Now please come to 62.4. UGC regulation 2010 are directory for universities, colleges, and other higher educational institution under the purview of the state legislation, as the matter has been left to the state government to adopt and implement the scheme. Thus, UGC regulation 2000 are partly mandatory and partly directory. So, my lord, now, my lord, Arsana Sharma is a professor of the, my lord, Guwahati University, for whom I I filed a writ petition. She was also an aspirant for the post of, my lord, Vice Chancellor of Guwahati University. Now, my lord, there a question arose whether in selection of Vice Chancellor, Guwahati University Act will apply or UGC norms will apply. There the stand of the state government was, my lord, it's a reported case that we have not adopted, meaning they have gone by Kalyani Motivanan. So, my lord, in this case, there is no dispute that on the date of advertisement, net slate was not a requirement. It became a requirement post 13/1/2000.
Right, let us assume that
Yes,
to be
yes.
in that manner.
Yes.
But then your appointment letter.
Now, I'm coming, my lord. I'm coming. Now, my lord, this. Yes. My lord, in Jyoti Rupa's case, Jyoti Rupa Sharma's case, my lord, Arya Vidyapeeth College, amongst others, issued an advertisement in 1998 for appointment to the post of lecturer in anthropology. Selection committee gave her first nominee, but, my lord, the governing body, while forwarding the resolution, forwarded the name of the second nominee. I immediately came to the Honorable High Court, but by the time, my lord, the writ petition was decided, sometimes in 2004, I still remember Honorable Justice Jain Sharma delivered their judgment, my lord. Writ petition was allowed, there was a direction for appointment. Now, my direction for appointment is relatable to, my lord, my 1998 selection, when these requirements are not there. Then, my lord, there was a DPI who had lot many contempt cases in this High Court, my lord. Every day I used to see him loitering in the corridor. He did not pass any order. I instituted a contempt proceeding. An order for personal appearance was given. On that day, my lord, he came up with a order of final approval, formal approval, where she said, I must clear net and slate. My lord, in that situation, my contention was, my advertisement is of 98. It was accepted in 2000. How can it be, how can that be insisted upon? That is the case there.
In Jyoti Rupa.
Jyoti Rupa. Now, in this case, my lord, my case is, advertisement is of 99. Adoption by state is of 2000. How can we insist upon it? Now, my lord, now there is a recent Constitution Bench judgment on this point. Kindly have a look at this, my lord. That is my last submission. I will not mention this proposal here. Second, my lord, Manjushri, lordship, there are a line of decisions where it says, once the game has been played pursuant to the advertisement, while the game is being played on, you cannot change the rules of the game. That was the holding in Manjushri. Now, some judges doubted the, my lord, correctness, and the matter was referred to a Constitution Bench Now, my lord will kindly come to para 42.
Yes.
We therefore answer the reference in the following terms. Recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless extant rules so permit, or advertisement which is contrary to the extant rule so permits. Even if such change is permissible under the extant rule or advertisement, change will have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Now, this is important. Decision in Manjusri is a good law and is not in conflict with decision in so-and-so, deals with the right to be appointed from the select list, whereas Manjusri deals with the right to be placed in the select list, 2 cases, etc., etc. So therefore, my lord, the Constitution bench upheld Manjusri. In Manjusri said, whatever was obtaining on the date of advertisement, that will govern the recruitment. Now, in this case, my lord, admittedly on the date of the
You
advertisement,
have demonstrated.
yes,
But only,
yes,
now let's come back to
Yes.
the appointment order.
yes, yes. Now I am coming to that ground that I have accepted.
Hmm.
Now,
Why,
my lord,
why
we-
was that
Yes,
kept?
yes. My lord, my humble submission is, my reply to that is based upon the judgment in Baseswar Nath's case, where Supreme Court says, my lord, there is no question of we as a citizen, my lord, giving up or waiving fundamental right. There my lord, I'll place the judgment, I'll give the judgment on Monday, my lord. Baseswar Nath versus State of UP.
In that, let's have this
Yes.
matter fixed on Monday, on which date you can give that judgment, and
Huh.
Mr. Gogoi,
Huh.
you can just check up
Hmm.
as regards the status of that cabinet
Oh, yeah.
proposal. Let
that
that
is
be,
not-
you
that
see,
is,
because that document is on record, so
Lord.
the petitioner has argued now.
No, that was never.
Correct, but that stand of yours is
Lord.
not there in your affidavit. If it would have been mentioned in your affidavit that that is the
No,
mere
it's not an
proposal.
affidavit, my lord. At
Even-
least some communication from the
Even lordship.
Chief Secretary's office that this
For
OM
for a
was.
moment, for a moment, we assume that that is their lordship.
See, that is a different thing,
Then
Mr.
also it is
Gogoi.
not there.
But you
Lordship.
see, you may know all the facts,
Lordship.
but the court does not. The
Other-
court has to, now when the issues are brought before the court,
Lordship.
the court has to
Decide.
decide those issues. I cannot ignore it, correct? Now, if I decide and that point is left in that manner, tomorrow I may be criticized that why I didn't call for the records and checked what had
Yes,
happened.
you may call for a record also, lordship. It is,
You
because
can
this
have
record
it.
is not existed.
See, Mr. Gogoi,
Lordship.
all that this court wants to know is the fate of the
Lordship,
that
Lordship.
cabinet
I
proposal.
think, my
correct?
lord, my humble submission.
have
would
an
be, my lord, I
instruction.
think my learned friend can write a letter to the Chief Secretary's office.
You get
that
hold of the
whether
instruction, I will
This cabinet
make it a
memorandum
part of
was
the
taken to
record.
its logical end. That's
Mr.
all.
Gogoi, you get it by way of a written instruction, I will have it up, I will take it up as a part of the record.
Yes.
Monday it is not possible.
When do you want it next?
Next, when? One.
Then I think because, then let's have it either the next Thursday. Next Thursday is okay. Wednesday, Thursday, Friday, any day. You can have it.
Well, let it on Wednesday. Thursday, I'll go to Delhi, my lord. There's a 4 o'clock thing.
All right, Wednesday.
Wednesday.
Uh,
6, there is a matter in Supreme Court.
Hearings concluded. However, Mr. K. Gogoi, learned additional senior government advocate, shall apprise the court on the next date of listing as regards the status of
The cabinet memorandum.
where is it? It's on 44, no page?
Yes, ma'am.
Of the cabinet memorandum dated,
Date to 9
is there a date?
There is no date, my lord. File number is there.
Even also it's a
File number
it's a type copy. It's a type
B28274.
copy, origin copy also not here. Lord. It's a type copy.
So get hold of
Lordship,
your instructions, Mr. Gogoi. Why
Lordship,
what is
Lordship,
the
I will-
difficulty?
I will place it. I will
You
place it.
place it.
I will place it.
Uh,
Lordship, from where, how we
Cabinet
can,
memorandum,
should be. And from where they have typed.
In
it also
file
not there.
number, my lord.
VD file number, capital B, bracket 2, capital H 274 stroke 2004,
Yes.
purported to be a proposal for treating lecturers appointed before 13/1/2000 and after 13/1/2000 to 25/2/2003 having equal status as one group to enable the later group to enjoy all kind of benefits and privilege, including promotional benefits, etc. Stuff. I'm not saying about your judgment that you give, and Mr.
My lord,
Gogoi.
I'll place the
I-
Baseswanath
I-
judgment where, my lord, even if a citizen waives, court will not do that.
And Mr. Gogoi,
I
all
will place,
this,
Lordship, I will place that particular conditional appointment. I will place 3 constitutional bench judgment of the Honorable Appeals Court.
Further.
One recent judgment also, Lordship. I will place
Further.
it, Lordship. Further, I will place it, Lordship. Yes, because that point was raised Baseswanath, so I have placed the constitutional bench judgment
very.
where it says that
uh,
if you accept the condition, is bound by
Mr.
the
Gogoi, you
condition.
do one thing, on Wednesday, you give a compilation
no, I-
of all the case laws and the UGC norms, whatever
sir.
you have given,
Lordship,
because these are all your copies.
Lordship, yes.
So you give them, but only thing is that I have already made some marking. So when
no,
you
no
give,
issue, no issue,
so
Lordship.
when you give, you highlight those.
Lordship.
Otherwise, it becomes very difficult.
Lordship, 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 Lordship.
And once I reserve, I don't
Mr.
feel
Gogoi,
comfortable to
Mr. Gogoi.
call anyone. So
Right.
it becomes
For
very
second-
difficult, when fresh copies are given to the
Lordship, speak
court.
of court, Lordship, Lordship made a second week of December, Lordship.
Hmm.
First week I will be not here, Lordship. So,
Mr.
second week
Gogoi,
of-
any dates?
Second date, my lord, no
Second.
problem.
Give a
Only thing
date.
is not on 12th.
On
Give a date. Both of you,
On
any
11
conscientious date.
11
It
or
can be on 11th.
11.
All right, all right.
11.
List on such and such date as partner. Huh?
And I will make a
Mis-
compilation
Mr.
of all
Chaudhary,
judgment. I
please
will
ask your junior
Hello,
also
what
to
I'll
just,
do, I'll just make a small retainer.
and those case laws, you can just put it in the by way of an
Yes.
index.
yes. Just 2-page note I'll give.
Yes, yes. কালকে এই করলে বাদে আর ইয়ার নোটস তো আছে
Dep-